The racist history of U.S. immigration laws. Immigration policy is at the forefront of politics in the United States. It's thus hard to imagine a time when the country had no immigration policy. Yet, just over 100 years ago, there was no border patrol, and passports and visas were not required to enter the country. The United States was a sovereign nation for a full century before immigration restrictions became a subject of political debate, let alone law. When the United States began to pass immigration laws at the end of the 19th century, these laws were overtly racialized and expressed a clear preference for people from Northern and Western Europe. The first major piece of immigration legislation was the Chinese Exclusion Act, signed into law in 1882. This act was overtly racist in that it targeted one specific group, Chinese laborers. In 1924, Congress passed two additional laws restricting immigration: the Immigration Act of 1924 and the Oriental Exclusion Act. These laws were designed to improve the racial stock of the United States. In the hearings leading up to the passage of these laws, Senator James Phelan testified, "We cannot absorb the large influx of people from Europe, and certainly not from Asia at all. The Oriental races are not assimilable. The races of Europe are potentially assimilable. We can make, in a few generations, a good American citizen out of a boy from France or England or Scotland or Ireland or German or Italy. Not so the black and brown and yellow races." These acts effectively cut off immigration from most countries. The Immigration Act of 1924 greatly reduced immigration from Southern and Eastern Europe by introducing quotas or limits on the number of people from these countries who were allowed to enter the United States. The 1924 Oriental Exclusion Act expanded the Chinese Exclusion Act and prohibited most immigration from Asia. These quotas and restrictions were finally repealed in 1965 with the passage of the Cellar Act. Although these racist laws have been repealed, the court cases that stem from them continue to shape how we treat immigrants today. For example, Fong Yu-ting, Wang Quan, and Li Zhou, three Chinese laundry workers living in New York City, were arrested and ordered deported in 1892 for not having certificates of residence and thus being in violation of immigration laws. They appealed their deportation orders, claiming they should have the right to a trial by jury before being ordered deported. When their case reached the Supreme Court in 1893, the court decided that the power to deport non-citizens was inherent in the nature of sovereignty and that constitutional protections, including the right to a trial by jury, did not apply. This case defined deportation as an administrative procedure and not a punishment. According to the Fong Yu-ting decision, which still holds in court today, deportation is not punishment, and thus people facing deportation do not have the right to a trial by jury or other constitutional protections. It is remarkable that this court decision, which was made in the context of strong anti-Chinese sentiment, continues to hold legal precedent today. Today, just as in 1892, people facing deportation are denied constitutional protections, And today, just as in 1892, most people facing deportation are people of color.